Hey everyone, Harry here to talk about the Department of Justice's reversal of position in the E Jean Carroll case. And to cut right to the headline, it means that the department's efforts to make that case go away are over. All right, let's review the bidding because it's pretty important to what happened yesterday. Trump is sued for defamation by E. Jean Carroll for making these comments after she sued him, or after she alleged, in the public sphere that he had assaulted her. He said on the White House lawn, you may remember to reporters, very, very Trumpian, she's making it up. She's not my type was one of the things he said, as if that's, related to whether he would have raped her in a department store in 1991. And he basically called her a liar and unattractive. And that was the basis of her defamation suit. She brought the suit when Bill Barr was still the Attorney General. That matters a lot because the Department of Justice will defend any federal employee accused of violating of a civil suit in circumstances where they are acting within the scope of their employment. You are somebody driving to a deposition, you get in an accident, the department will step in and defend you. It will provide the legal defense, and it also means that you don't have to pay lawyers or anything like that. In this case, though, it meant something more. And that's because under the principle of sovereign immunity, the United States gets to decide what cases it will agree to let people sue it for. And it has decided that negligent torts are one thing, but intentional torts, and defamation is an intentional tort, says it won't be sued for. So if they take over the case for Donald Trump because Donald Trump is acting within the scope of his employment, that means that the case, if the court accepts their position, will just go away. It just cannot be brought. So the stakes here have always been high. Now, from the time that the department, and here's the sort of second big point, first adopted this position, a lot has happened. First, you've heard, of course, that the E. Jean Carroll trial went forward. That is a second trial based on the sexual assault itself primarily, because New York passed a law that said victims of such events can sue for a year period, even if it was a long time ago, as this was. So the case we're talking about is the very first defamation case. And that case, after the Department of Justice came in, took a very circuitous route through the federal courts. And that's because first the district court, then the Court of Appeals in New York, then the court in DC were asked to opine, what does it mean for someone to be acting within the scope of his or her employment? Anybody, in this case, Trump. And the answer came back that, among other things, under the law in DC, where it matters, the subjective feeling and intent of the actor matters a lot. All right, back to DOJ. Third point here. When Merrick Garland comes in, he's really at pains to not make the department look political and not just shift in the political winds by changing all the positions, especially in politically charged cases. So it's clear that it was always kind of dubious to say Trump is acting in the scope of his employment when he defames her to the press. But the Bill Barr DOJ had so concluded, and the DOJ under Merrick Garland decided to stay the course and take that position. And that's the position they were taking as this case went through the various courts that I described. Now it's come all the way back to the original district court that had it, with guidance pretty murky, but basically saying apply this multi-factor test. And now it was time for the DOJ to give its opinion. Do they still believe that Trump was acting in the scope of his employment? Yesterday, here's the headline, they said No, we've changed our position. And why is that? A few reasons. First, the courts have instructed subjective factors really matter. And you can see that Trump is really mainly in his Trumpian, vengeful way, trying to just have a reprisal on E. Jean Carroll and be, nasty and personal rather than actually attending to the public interests of the people of the United States. And moreover, and this is classic Trump, self-inflicted wound and hoist by his own petard, he said afterwards, including at a CNN interview, she's a whack job, and said other things that made it more clear, said the Department of Justice yesterday, that this is about personal reprisal for him, not about his august duties as president. And indeed, it's pretty clear that it is. It always was, really, but they had stayed with that borderline, or you could even say dubious judgment call until yesterday, when they now said, with this new evidence considered of his subjective state of mind, also with the fact that a jury has returned a verdict of sexual assault, all in all, we can't say that there's really evidence anymore that he was acting for the interests of the people of the United States. Therefore, we are changing our position. We're not defending him. He's on his own. He'll need his own lawyer. And most importantly, the case will go forward, and it will go forward under Judge Kaplan, who has made it clear he's all business and wants the case to proceed January 2024. He set a trial date, and he says it's going to hold, and this has to be considered among the big sort of trains that are bearing down on Trump, in addition to all the criminal stuff. So as of yesterday, the department is no longer attempting to defend Trump or say he acted within the scope of his employment. That means full speed ahead and green light to E. Jean Carroll's original defamation suit brought in 2019 or whenever it was, which we can look to go forward in January. And the prospects in New York for this case for Donald Trump look very poor, I would say. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.